recording, so. All right, I'm going to go ahead and get my gavel out. Good morning. I'm going to go ahead and call this session of the City of Issaquah Hearing Examiner to order. For the record, we have one item on the agenda this morning, and today is October 20th, 2020 at 9 a.m. This is, I think, numbers BLD 18-00355, APP 20-00001, BLD 18-00187, APP 20-00004, BLD 20-00004, BLD 19-00299, BLD 19-00298, BLD 19-00297, and BLD 19-00296. If I missed any, we'll sort it out down the road. But essentially, this relates to appeals of certain building permit fees related to the Polygon properties here in the city of Issaquah. So this matter has been sort of rescheduled multiple times by agreement of the parties to try to sort out issues in advance. Just last week, we had some other issues come up. But all the parties are represented by counsel, so I think we can quickly move toward hearing from the attorneys. But I am Andrew Reeves, hearing examiner with Sound Law Center, who the city has selected to hold certain hearings like this one. And it will be my role today to collect evidence in the form of exhibits and testimony to determine whether the appellant has shown that error has been made in this instance. So all testimony will be under oath or affirmation. Again, the parties are represented by counsel who all know how this process works, so no need to belabor the point. So at this point, I think we'll start with counsel to find out, again, what happened. I think it was last week at this point, was that we received a decision from the Superior Court in an associated matter. There was a request for briefing, which I ultimately denied, but I did indicate there'd be an opportunity to discuss that and potentially make arguments at the outset today. So I'll first turn to, let's see, I see Duana there. Ms. Koloshkova, I'll start with you as the appellant, if you want to speak to this issue and introduce yourself.
Oh, okay. Good morning, this is Duana Koloshkova. Pausing, I thought I had an echo, but I don't. Thank you, and I am here representing the appellant, which is Polygon Northwest, since has been acquired by Taylor Morrison. So just to clarify that for the record, if anybody ever sees the Taylor Morrison logo, that's the backstory. I don't know if we just lost the examiner.
Sorry,
Okay. Oh, okay.
I was trying to fix the lighting in my room. I apologize.
And I must say, just off the record, the Shoji screen is smart. I'm gonna borrow that. So we're prepared to address Judge McHale's decision, just as sort of just to maybe organize the morning a little bit. I do plan to bring one witness, Connor King, who is present, and we've tested his mic. Probably have about maybe 10, max 15 minutes worth of testimony from him, absent questions from Ms. Hambley or the hearing examiner. And we can present oral argument and available for post-hearing briefing as well. So with that, I can talk a little bit about the court's decision or proceed however the examiner wishes.
Like I said, I wanted to give a brief opportunity to talk about it. If I think it makes more sense at the end, that's fine. But whatever you think makes the most sense in terms of figuring this issue out.
Well, okay, I'd be happy to sort of jump into that piece, especially since it's a bit of the elephant in the room, having a LUPA decision related to the same projects and the same sets of invoices for the Westridge North projects. And Mr. Examiner, having appeared before you before, I'm aware that you have a history of reviewing the briefs and the records prior to the hearing, so I won't do too much basic background, though if the examiner wishes me to, or the witnesses, I certainly will. Judge McHale issued his order granting Polygon's land use petition on, I believe it was October 2nd. And therein, The reason, well, first off, the parties, I think, both agreed that the examiner should be aware of this decision, but we also recognized that the parties disagree as to both the relevance and the weight that the examiner should give it. From Polygon's perspective, while the LUPA petition certainly deals with a different set of fees, general facility charges, primarily that the city has different statutory authority to adopt, namely under Chapter 3592, the legal determinations and some of the factual determinations that the court made, Judge McHale, are directly relevant to, and we would argue binding upon, this hearing examiner. The general facility charges that were an issue in that case were established as part of the development agreement process, just as impact fee rates or credits and mitigation fees were. All these fees were addressed as part of the development agreement, and Judge McHale held that Polygon's Westridge North projects were entitled to proceed based on the determinations made in that development agreement. And I think a very important component of that is because development agreements address things called development standards, which expressly include under RCW 3670B 170 impact fees, mitigation fees, and the like. I briefed that in writing and we're happy to revisit that. But that determination of fees under the development agreement that Judge McHale made, and particularly the conclusions on page 5 of the order, are almost directly translatable to the impact fees and mitigation fees that are primarily at issue in this case. In both respects, the city expressly evaluated what would be required in terms of land dedication and infrastructure improvements in order to address the city's public utility needs. And in both cases, the city determined that the construction of that infrastructure, dedications of land, all of that fully mitigated. And so when the judge stated the termination of the development agreement alone is not a sufficient basis for newly applying the GFCs, I'm paraphrasing that second part, that same conclusion holds for this case, as the city's only argument, again, is the same as it was before the court, namely the termination of the development agreement should give the city, based on its briefing, carte blanche to impose all of its current impact and mitigation fees. That is the very argument that Judge McHale rejected. I think I'll leave it there because otherwise the conclusions speak for themselves. And I'm prepared to proceed with my case in chief. Again, just have one witness, as we believe most of the issues are really, frankly, questions of law and deal with the written record.
Sure. And to that end, just to be clear on your exhibits, I think initially it was A1 through 18, but then this is now Judge McHale's materials became A19 and A20. Is that what you have?
One moment, let me just confirm that. Yes, I'm through A20. And okay. The A20 we included just to keep I think it's fair to say, just to keep the record clear, because there was some jurisdictional kind of back and forthing on some of the permits early on. I don't plan to present any particular argument related to that, but again, it's a court order related to the same projects that the examiner is reviewing.
Got it. And then this is a new system for all of us, I think, but I look at Judge McHale's order, it doesn't appear signed, but then there's an extra page. Is that the way they're doing it now in Superior Court?
Correct, that's my understanding.
So it was from October 2nd, it would be the date of that. Okay, so Connor King would be your one witness. I'm gonna turn it to Kate Hambley just for a moment to introduce herself and see if she had any thoughts before we move on with the appellant's case. So, Ms. Hambley, thank you for being here.
Thank you, Hearing Examiner Reeves. As you said, my name is Kate or Catherine Hambley. I'm representing the city of Issaquah. My supervising attorney, Jim Haney, may be ducking in and out of these proceedings to observe, but I'll be presenting the city's case. We have several city witnesses observing at the moment: Doug Schlepp, Michelle Wright, Keith Niven, and Lucy Sloman. We may also bring in a few other witnesses listed on our list as needed for rebuttal, but they're not presently part of the meeting. With respect to the McHale decision that appellants just discussed, I'm happy to present oral argument on that. I would like to ask the hearing examiner as well if we could have an opportunity for addressing this in written post-hearing briefs. I think you might have indicated that was appropriate, but it's not in the pre-hearing order, so I just wanted clarity on that before.
Yeah, we'll see what happens today, obviously, but I think it would be appropriate to include a section in any post-hearing briefing on this particular issue. Absolutely. So. Thank
you, Mr. Examiner. I just say that because I'd like to give a brief overall picture of what we think these decisions mean, but some of our arguments about why they're different are fairly nitty-gritty, and it's just easier to do the writing. But overall, the McHale decision, as Ms. Koloshkova explained, dealt specifically with general facilities charges. And more specifically, they were confined to the Westridge Single Family North project. The permits at issue here involve both Westridge Single Family North and Westridge Townhomes North. In order for this decision to be in any way binding on this proceeding, it would have to be through the doctrine of collateral estoppel, which, as I'm sure the hearing examiner knows, requires absolutely identical issues. And I think Ms. Koloshkova has already acknowledged one major point of distinction, which is that the statutory authority for the fees at issue in the McHale case is completely different from the statutory authority underlying mitigation of impact fees here. And that's an important distinction. One of the most important differences between these two statutes is that the impact fee statute, which we'll be arguing about today, requires cities to create a process for an administrative adjustment of fees, sort of like a safety valve to make sure no unfairness occurs. And that's going to be a major part of the city's argument here. That did not feature in the McHale decision at all because the GFC statute makes no provision for that adjustment. Our code makes no provision for an administrative adjustment. In fact, the city felt we couldn't deviate from our code requirements for GFCs because we had no code-based authority to do so in that case. So the McHale decision really speaks to two issues, and one is what I just mentioned, which is, are the fees authorized under their respective statutory bases, impact fees in this case, GFC statute, and the McHale decision. The other issue, the elephant in the room, as Ms. Koloshkova says, is vesting. In this case, before the hearing examiner, we've argued the hearing examiner can't consider vesting. I consider that to be somewhat of a bedrock of hearing examiner practice. I think that is reflected in the holding in Wells v. Whatcom County Water District, which we cited in our briefing. And I think in the McHale decision, petitioners also made a very different vesting argument than they're making here. In the McHale decision, the hearing examiner is not aware of this because he doesn't have the briefing in front of him, but petitioners made a full-blown, pure legal vesting argument, arguing both that they were vested because of the development agreement vesting statute and because of the preliminary plat vesting statute. In this case, they're not really making either of those pure vesting legal arguments. They're saying that because we agreed in 1986 that their project was fully mitigated, we have to continue that now because it would be unfair under Chapter 8202 to do otherwise. So basically, it's a different argument on vesting. And I think even more importantly, the McHale decision on vesting isn't all that clear to me because in one conclusion, he says that Westridge or Polygon is vested to their mitigation. I'm paraphrasing, but it doesn't say to fees, it says to mitigation. And then in the actual order, Judge McHale said that the city had to assess the fees applicable to GFCs under the development agreement unless and until the city passes a new GFC ordinance that sets new fees for Westridge that are defensible under 3592025, the GFC statute. So if Judge McHale had decided that Westridge were vested under a pure vesting theory, it would not have been appropriate to allow the city to pass a new ordinance applicable to Westridge that sets new fees. That's contradictory to the idea of vesting. So to summarize, on the statutory authority issue, we're just in a totally different statutory paradigm that has different legal standard, different features, including the administrative adjustment process. On the vesting issue, not only is that outside the scope of the hearing examiner's review, it's just not clear to us that Judge McHale even made a clear holding regarding vesting, nor were the vesting arguments presented in the McHale case the same as are being presented here. And I'm happy to address all of that again in post-hearing briefing.
Great. And to be clear, I mean, my read of Exhibit A20, Judge McHale is retaining jurisdiction over this matter. Is that accurate?
That's my understanding, but I think it was, allow me to refresh my memory here, partly because the city needs to issue a refund for some of its fees.
Okay. And then in addition, I had noted that for city exhibits, my notes show C1 through C28. Is that what you have?
The city submitted additional exhibits with its response brief, which we understood petitioner stipulated to.
Sorry.
Yeah, there we go. So, no problem. So we have through C34.
That's what, yep.
Okay, yeah.
My notes say through C34. There we go.
Great. And Mr. Examiner, we do have a small housekeeping item regarding Exhibit C12, if now is a good time to raise that.
Sure.
In reviewing exhibits, I noticed that the city labeled Exhibit C12 as the invoice for building permit 19-00204. If you go to that exhibit, you'll find it's actually the invoice for 18-00187. So we submitted the wrong exhibit. I have the correct exhibit here. It's, as Ms. Koloshkova has pointed out to me, pretty similar to the exhibit at C13, which is the cash register receipt for building permit 19-00204. I would just like to get the correct exhibit C12 into the record just so we have a complete record. I've prepared a clean version of that to be exhibit C35 so it doesn't mess up any Bates numbering. If the hearing examiner and petitioner will stipulate to that admission, that'd be great. But if not, I can introduce it through testimony.
I have no issue, Ms. Koloshkova. C35 is what B12, or excuse me, C12 should have been. Is that right?
Yeah.
I think that's fine. I would note, yeah, that their exhibit C13 is actually several pages long. So just to be clear, it's not just the receipt. There's some other documents attached to that.
Yeah.
Thank you for clarifying that.
Okay, so C35 is what C12 should have been. It's essentially the invoice related to BLD 19-00204.
Well,
That's correct.
That's sort of, we'll provide some testimony on this, that it was the second of a series of invoices. There was a prior invoice as well that's already in the record. So just to be clear.
That's right. It's an invoice that the city issued for 19-00204.
And then this document that is related to BLD 18-00187 is totally unrelated, correct?
No, it's related to these proceedings, but I believe it's duplicative. Let me just confirm that. Yeah, I believe it's duplicative with C-08.
Okay. Okay, then does that then handle the matter of exhibits at this point, Ms. Hambley?
It does, and I have an email queued up with my attachment of C35 to David at Sound Law Center, Candy at Issaquah, and Andrew Reeves at Sound Law Center with Ms. Koloshkova CC'd. Is there anyone else you want me to add to this email?
Oh, could you add Benita, please?
Sure thing. Okay, I'm going to shoot this off right now.
Great. So then I think at this point we can move to Ms. Koloshkova's case and her witnesses. So.
I do, Mr. Examiner, have one clarification as to something Ms. Hambley said related to the McHale decision that I do think is actually important to clarify here. This decision is not limited to just the single-family building permits. I was not aware that that was going to be the city's position, and it's not clear to me that it is. We actually entered into a stipulation before the court, which is not in the record here, that this decision pertains to all the Westridge North projects. If that's a matter of dispute by the city, then I will be moving to enter that stipulation in order into the record for this case.
May I ask? Oh, thank you. The city completely agrees that it has stipulated that the McHale decision regarding GFCs, we will apply that holding to GFCs for Westridge Townhomes North. I'm sorry, I should have made that clearer. The point I was making, though, was that the record before Judge McHale, the briefing before Judge McHale, the oral argument before Judge McHale, and presumably his decision is entirely based on a record surrounding Westridge Single Family North. We had no decision, no exhibits, and no argument surrounding the import of the SPD decision, which is a totally different type of permit for the Westridge Townhomes North. So we've agreed to take the holding and apply it to other units for the sake of simplicity, but Judge McHale had no briefing or understanding of what was going on in Westridge Townhomes North.
I'd have to disagree with that. The stipulation that we entered into before the court was entered 2 weeks before the court's decision. I totally agree the record was based on the single family units, although there was some limited discussion about the larger projects, but the stipulation clearly came in and was signed by the court 2 weeks before its own decision. So again, the court's decision does expressly pertain to all of the Westridge North projects.
May I, for one thought in response, Mr. Examiner? So we agree, the city agrees that we submitted the stipulation before Judge McHale issued its decision. Perhaps a better way to frame this is that collateral estoppel requires, in order for collateral estoppel to apply, each party must have a full and fair opportunity to litigate all issues. We had no opportunity to separately address vesting in an SPD decision versus a preliminary plat, which actually has a vesting statute associated with it. So it's true that we are applying the Judge McHale's decision to the units in Townhomes North. We do not agree that the scope of that decision took Westridge Townhomes North into consideration.
Ms. Kolishkova, did you want an opportunity to submit or potentially submit additional materials into the record as you indicated?
I think I do have to move to include the stipulation in order that was signed by the parties, because I would certainly disagree with the city's position that somehow the decision should not pertain, or I guess that the city is volunteering that McHale's decision pertains to the townhome building permits, and especially to the extent that the city may now try to argue that that somehow should affect the hearing examiner's, I guess, weight and understanding of the effects of the decision on his own rulings. So I will move to enter into the record the stipulated motion and order signed by the parties on December 21st in the McHale case and signed by Judge McHale on September 23rd. I can do that in a written motion later, or I can circulate it by email now, whatever makes the most sense, and I can share screen it as well.
Ms. Handley, any objection to entering that stipulated motion as Exhibit A21?
No objection. I would ask for an opportunity to also submit the parties' briefing before Judge McHale in the related case, in post-hearing briefing.
You mean as additional exhibits, you want to submit the briefing that was produced for Judge McHale? I mean, how much briefing are we talking about?
I believe there were 3 briefs, and what I'd suggest is that I submit them as attachments to a declaration along with our post-hearing brief in this matter, rather than as exhibits here, as I don't have them. I mean, I can pull them up, but I don't have them pulled up right this minute.
I mean, I have no issue. Ms. Kolishkova, do you have any issue with that?
No, I don't have any objection.
So we'll get a full and complete record, but essentially the stipulated motion and order will become Exhibit A21. And then Ms. Handley has indicated that as part of an attachment to the post-hearing briefing in this matter, we'll have the briefing that went to Judge McHale and I might give it exhibit numbers, and we'll see. I don't know. Just so that we have a clear record, it'd be convenient to have that. But does that? So I understand the arguments, I think, but does that basically take us to the point where we can begin with our testimony?
Yes, I'd just like to clarify one other thing, which is my understanding is we are completely stipulated as to all the exhibits we just discussed, so there's no need for authentication. Is that correct?
Correct,
Yeah.
Mandy.
Great, thank you.
If I may, I'm just going to circulate the stipulated motion before I forget to do that, please. As Exhibit A21. Thank you. Thank you very much for letting me do that so I don't forget later. I appreciate it. And hopefully also, Ms. Hambley, I think I got the right email string for purposes of your exhibits later too, the C35. Again, we would like to bring as a witness Connor King, who is present with us. And Mr. King, you can take yourself off mute, please.
Great. All done.
Oh,
Test.
that's there's some background noise, but hopefully.
Is this any better?
Yes.
Okay.
Okay, I'll get you sworn in, Andy. Swear for him to tell the truth in any testimony you give here today.
Yes, sir.
Great, thank you.
Good morning, Mr. King. If you could please state your full name and professional address for the record.
My name is Connor King, and my professional address is 13810 Southeast East Gateway, Bellevue, Washington 90005.
Okay. And do you work for a company named Taylor Morrison, formerly known as Polygon Northwest?
I do.
And what is your title or role with that company? And I'm getting a little feedback. Is that you?
Apologies. Let me try and clear some of my.
There's in the room there.
Hopefully that is a little better.
Much better.
Okay. My apologies for that. Duana, I am the permit coordinator for Polygon / Taylor Morrison. My duties include the submittal, revision, coordination, issuance, and payment of all building and utility permits in the case of Westridge.
Okay. And have you been able to compare building permits for the various Westridge, I'll call them Westridge North and Westridge South projects?
Yes, I have compared almost every issued permit to a similar permit at Westridge South and compared the differences in fee structure and amount.
Okay. And when I talk about projects known as Westridge South and Westridge North, am I using terms that are familiar to you?
You are.
Did you, let me start with this. Did you have an opportunity to review correspondence from the city of Issaquah dated March 27th and November 22nd, 2017? Signed by Keith Nevin, the Economic Development Services Director?
Yes, my former boss, Nick Abelnauer, provided me with those letters from Keith. And I was informed we were not to pay any more than we did at Westridge South.
Okay. And Polygon's understanding was based on those two documents?
That is my understanding, yes.
Now, for the record, Mr. Examiner, those exhibits A2 and A4, I don't have any particular questions, although I'm available to share my screen at any time to pull those up if we need.
I know them intimately. It's okay.
Thank you, Mr. Salmon. Did you ever receive any correspondence from the city that either retracted or gave you a different instruction than what was provided for in these two letters?
I never, nor any of my staff, I believe, received any correspondence of any such regarding that.
And just one question to clarify. Actually, if I may, can I ask you to mute your microphone when I'm talking in case that cleans up this feedback? Ah, perfect. Thank you. Okay. I'll just make sure I pause after I ask you a question. Thanks. Okay. These letters refer to residential development of something called Parcel D. Could you tell us what Parcel D is, just so we're clear?
Parcel D is a future single-family development that lays to the east of the bulk of our Westridge projects.
Okay.
Separate from Westridge.
Okay. Okay. And so after reviewing these letters and receiving building permits for the Westridge North projects, let me ask you that differently. I'm sorry. So you already testified that you had compared fees between the Westridge South projects and the Westridge North projects based on these letters. Is that correct?
That is correct.
Okay. And for purposes of the Westridge North townhomes or multifamily projects, are you familiar with a table that compares 4 multifamily building permits that we've called Table A attached to the briefing?
I am familiar with that. I put that together to represent the amounts and fees that we paid for the permits.
Okay. And when you put that table together, was that based on the invoices provided by the city, or did you use any other information in order to compile these numbers?
I only used the information from invoices for which we paid the permits.
Okay. And at the time you received these invoices, did you receive any other emails or letters or other form of explanation as to why impact fees were being assessed for these permits?
I received no explanation for why impact fees were assessed for those permits, not at all.
And same question as to the mitigation fees. Did you receive any correspondence of any sort at all about, or even phone calls about mitigation fees being charged on some of these permits, although not all of them?
To my knowledge, I received no verbal or written correspondence or explanation of that.
Did anybody else at Polygon tell you they'd received any correspondence or share anything with you?
I don't think so, no.
And let me ask you about the single family, Westridge North single family project. Did the city, at what point did the city start assessing impact fees on the Westridge North single family project?
If I remember correctly, they started assessing impact fees for their single family north in August of this year, so August 2020. Yes.
So were there building permits for Westridge North, the Westridge North single family development, which did not have impact fees or mitigation fees associated with those?
Yes, there were 6 permits issued before August 2020 that did not have impact fees assessed for those.
And those were for Westridge North single family?
That is correct.
Do you happen to know the permit numbers for those? Oh, you're on mute. Hang on. You could start your answer over.
Apologies. Off the top of my head, I do not have those.
Okay, but you could supply those into the record if we needed those.
Absolutely.
And
Absolutely. That'd be a quick thing.
did you receive any emails or phone calls or correspondence explaining why no impact fees or mitigation fees were assessed on the first set of Westridge North permits, but then as of August, they were being assessed?
I received no explanation for why at multiple time points there were different fees assessed and different structures. I received no explanation for that.
I guess, let me ask you this. Did you ever receive an explanation for why fees were being assessed in a certain way for any of these building permits?
I did not receive any explanation for that.
Okay. I'm going to turn you back to the Westridge North building permits, and particularly building permit number 19-00204. And I'd like to share an exhibit on the screen, if I could, Mr. Examiner.
Sure.
Give it a shot. It's exhibit A6. Nope. Shoot. That's not it. Okay.
That looked like what I have as A6.
Oh, it did. Okay, I'm sorry. On my screen, it showed up as, let me try again. I apologize, everyone. I'm trying to learn how to do this correctly for the system. Okay.
It's not easy to see, but
Yeah, this is the only, okay. This is the only way it lets me share, but I'm referring to exhibit A6 for purposes of this testimony. Mr. King, do you have a copy of that exhibit before you? Or can you pull that up? Or can you see this? It is tiny, isn't it?
I can see the exhibit and it is before me. If you use the magnifying glass to the left, that may help everybody.
I'm really sorry, I can't seem to make that work, but I do have the exhibit open in a different window for myself. So do you, just to make this very simple, can you tell us, did you receive a copy of this invoice, which is dated February 19th, 2020?
I did receive a copy of that invoice. Yes.
Okay. And was that the invoice that you were ultimately asked to pay for that building permit?
That was the invoice that was uploaded, and upon attempt to pay it, the invoice was not there anymore.
Okay. And can you tell me what happened when you said you went to upload it and the invoice was not there? Is that correct? Can you tell me what happened after that?
I was told fees had been incorrectly calculated and they would be attempting to re-upload corrected invoice.
Oh, and did that new invoice get uploaded?
It did.
Okay. And I don't know if you have a copy of that now, but I believe that would be exhibit C35, Ms. Hambley. That would have been the March invoice. I believe Ms. Hambley's nodding her head for purposes of the record. Okay, and Mr. King, you received then that March invoice next, is that correct?
That was the next invoice that was uploaded. Yes, correct.
And then I will turn your attention to one more document, Exhibit C13, which appears to be yet another invoice in July for the same building permit with a total amount of $268,712.47. Have you seen a copy of that Exhibit C13?
I have seen a copy of that, and to my knowledge, that is what.
I'm sorry, you went.
To my knowledge, that is the invoice that I received and we paid.
Okay. Now, did you receive any explanation from the city as to why the fees were changed between those three invoices?
I received no explanation for why they were different at different points.
Ms. Koloshkova, am I missing something? What I have is C35, which is the new exhibit today, shows an amount of $268,712.47, which seems to be the same amount as C13. So I'm only seeing one change.
I am incorrect. I myself, Kate's laughing at me. I myself got my mind confused between the incorrect exhibit the city originally had. There are two invoices, that is correct, and they are all reflected. That final number is reflected in Exhibit C13.
Okay, so we went from a fee in Exhibit A6 of about 160,000 to then in C35 and C13 of about 209,000. Is that right?
Mr. King, if you'd like to answer that.
That is correct.
Okay.
And
I'm
Mr.
tracking.
Thank you, and I apologize too. There were so many different invoices. Now, Mr. King, included in Exhibit C13 is a letter from Polygon of payment in protest and a check in the amount of $268,000 and some. Was that those were the ultimate fees paid?
The 268,000 and change were the ultimate fees that were paid.
And again, comparing the two exhibits, there were no impact or mitigation fees in A6, but there were in C13. Is that correct?
That is correct.
I guess I should say, let me rephrase. I'm not sure there still don't appear to be mitigation fees in even C13. And again, that's reflected on your table A, correct?
I am bouncing in between the invoices.
I am causing you to do that. I apologize, but we kind of.
Agreed. Let's see. Ms. Koloshkova, can you please repeat your question?
Sure. Let me break that down. Between the first and second invoices for building permit 19-00204, there was a change in that the second invoice newly included impact fees. Is that correct?
The second invoice did include the new fees.
Okay. And if you would take a look at that Exhibit C13 in your Table A, it appears the invoice never did include mitigation fees for bike, pedestrian, general government, police.
That is correct.
And then just a couple more questions. I'm going to turn your attention back to that Table A again, where we were talking. That's where we started talking about building permit 19-00204. And it looks, sticking with the theme of the mitigation fees, it looks also that there were no mitigation fees issued in June for building permit 18-00187. Is that correct?
That is my understanding as well, yes.
And have you received any explanation for why some building permits are getting mitigation fees assessed and some are not?
Across any project, no, I've received no such explanation.
What is the current status of your attempts to pull building permits now for Westridge North? Are you still able to be pulling building permits, or are you waiting?
We have been unable to pull building permits for a while, as staff has informed me that they are working with their council to calculate fees.
Okay. I have no further questions for you right now, Mr. King, but the city attorney may have some cross-examination, and the hearing examiner may have some questions for you. I believe Mr. King will be able to stay the whole time, but I will make sure that he lets me know in case he needs to leave early if there is rebuttal testimony for any reason, which I don't anticipate.
Great. Ms. Hambley, did you have cross-examination of this witness?
I do have a few short questions. Mr. King, you've testified that you didn't communicate with the city and the city didn't communicate with you about rationales for these fees. Are you aware whether your attorney, Ms. Koloshkova, communicated on this issue?
I am unaware, but I'm unaware.
Okay, thank you. You also testified that for the Westridge Single Family North project, there were 6 permits issued for single family homes that did not have impact fees. Did I get that right?
That is my belief.
Were those single family homes model homes?
They were considered part of the model phase, but only 2 are model homes.
I'm sorry, I think that cut out. Could I ask the witness to just repeat the answer?
I stated the 6 homes were part of the model phase, but they only 2 of the 6 are model homes.
Turning to the building permit for, or building permit number 19-00204, that's a permit for a building in Westridge Townhomes North, correct?
Building 19-00204 is a permit for the Townhomes North project. You are correct.
And are you aware that the Townhomes North buildings each have a building number? For instance, building 1, building 2, building 3, etc.
I am.
Do you happen to know which building number this building permit pertains to?
Building 19-00204 pertains to building 12.
Are you aware whether there's an affordable unit in that building?
It is my belief that there is. I would need to double check that to be sure.
Okay, thank you.
And to clarify that answer, was that I believe there is an affirmative?
I would like to check my notes, but I do believe off the top of my head that there's one affordable unit within building 12.
I just want to clarify, you've testified that the city issued 2 different invoices for building permit 19-00204. Did you pay the first invoice and also pay the second, or did you only issue a check for the second?
You're on mute.
We only issued a check.
No further questions. Thank you, Mr. King.
Any redirect, Ms. Koloshkova?
Just one question on the last one. Mr. King, did you try to pay for and pull the building permit after you received that first invoice for 19-00204?
We did. When I went to the portal to print out the invoice that had been uploaded, it had disappeared.
So you were unable to actually pay and pull the building permit despite that being posted?
Yes, it was our attempt to pay for the $159,000 fees at that time.
And was there any other information posted on there as to why you were not allowed to pay for and pull the building permit and apparently then had to wait 5 months?
No information was given at that time.
Was any information ever given as to why you had to wait?
No information at all.
Thank you.
Great. Thank you, Mr. King. Just while it's fresh in my mind, and this is not a question for you, Mr. King, or, it could be for you or the attorneys, but just a point of clarification for me, we have a lot of different fees that are called different things. I fully understand, the difference between an impact fee and a GFC. There was reference just now to mitigation fees. Is this something being imposed under SEPA? Is this something that is also an impact fee under Chapter 8202 of the Revised Code of Washington? I know it's not a GFC, but can Duana Koloshkova, can you speak to that, or Ms. Handley, either one? Duana first.
Thank you. Yes, and I believe the parties have provided some briefing on that. Those are fees in city code that the city has adopted pursuant to SEPA, State Environmental Policy Act. There is briefing and disagreement as to the legality of the fees, et cetera, but I'll rest on the briefing for that for the moment.
Just wanted to make sure I had it clear in my mind. Ms. Hambley, do you agree then with that?
I do. The authority for mitigation fees comes from SEPA and the General Regulatory Authority over Land Use Permitting, and we feel has been blessed by the case Trinan cited in our brief.
Just wanted to make sure I understood all the different things we're talking about. So we've got GFCs, mitigation fees, and impact fees. Okay.
All parties agree that the mitigation fees are not statutory impact fees under 820205.
They're related to SEPA. Whether people believe it's doable or not is the idea. Got it. Thank you. So I didn't have any specific questions for Mr. King. I think then he might be sticking around, Ms. Koloshkova, but my purposes, we're done with him unless you recall him later. But.
Thank you, Mr. Examiner. And again, as we have previously stated, we believe, frankly, the nuts and bolts of this case revolve around the written record and the law as is being briefed. And I should note that Ms. Hambley and I did speak prior to the hearing based on the examiner's order about closing briefing, talked about timing. We're comfortable if the examiner ends up wanting closing briefing, however the parties want to go is going to be fine with us.
Okay. Then did you intend on calling anyone else? You had indicated you did not.
I do not. Mr. Abdulnur is no longer with the company and was not available to us, but I don't believe that his testimony would have been all that relevant anyway, because again, we're really talking about a written record.
And everyone agrees on, no need for foundation. We all know what Exhibit C2 and C4 say, which are his letters, and
we are not. We're not. We concur with the city that all the exhibits should be available to the examiner and should be admitted.
Great.
I will reserve any arguments for after testimony.
Great, thank you. So then, Ms. Hambley, at this point, I'll turn it to the city to present its case. Do you need a moment? Do you want to apply right ahead? What would you like to do?
I'm prepared to go right ahead. I do have a note on timing. I think this is a somewhat unusual case in that I completely agree that most of the issues are legal and can be addressed through documents, but unlike the typical appeal, the city actually has a few more factual points we need to get into the record than the appellant does. So I will try to be mindful of time, but I also just want to note the original meeting invite here runs through 11, and we may need more time than that.
I set aside all day, so I don't know if that's just a question of technology, but I didn't. Candy, are you there? Can we?
Yes, that's exactly right. We don't normally like to put an end time on hearing date on hearing examiner meeting set, but I don't also want a meeting that says 8 to 5 in case public come on at a later time. So we are willing to extend as long as necessary.
Okay, we're not going to get booted off the system.
No, we will not.
Excellent. Okay.
That's what I wanted to clarify. Thank you. My other just quick point is I wanted to dismiss Michelle Wright and Doug Schlepp, who were on here. They're welcome to continue to listen, but I don't intend to call them. So if you folks would like to tune out, that's perfectly fine.
Sorry, and that was Doug Schlepp, and who was the first one?
Michelle Wright.
Michelle Wright. Okay, thank you for being here, folks. And then who do you intend to call as your first witness?
As our first witness, we will call Mr. Keith Niven.
And if I go off video or off audio, I'm still here. I guarantee. I'm probably just taking a drink of my soda or blowing my nose or coughing. I'm trying not to be distracting. So, okay, Mr. Niven, do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you for.
And my understanding, Mr. Niven, is that you may also need to cut out your video due to internet connection issues. Is that right?
It's been off and on, so right now we're good. So let's plow through this.
All right. Mr. Niven, can you state your name for the record and your professional address?
Sure. My name is Keith Niven, and my professional address is 1775 12th Avenue Northwest, Issaquah, Washington, 98027, although I haven't seen it since March.
And what is your current title and position at the City of Issaquah?
My current title is I am Director of Community Planning and Development for the city.
How long have you been in that role?
So the role was previously Development Services Director, and I've been in this role formally since the summer of 2015.
Thank you. What was your position before your current role as director?
From 2012 until about 2018, I was the city's Director of Economic Development.
Are you generally familiar with the Westridge projects, and could you tell us a little bit about your involvement with those projects?
Sure. So Westridge is a number of projects being pursued by Taylor Morrison, originally Polygon Northwest. I believe there's 365 or so residential units. They are located, except for Parcel D, which was described earlier, west of 9th Avenue, north of Discovery Drive, and south of High Street. 100 of those units were allocated through the 9th major amendment of the Highlands Development Agreement, and I'll stop there. Go farther, but I'll stop there.
Thanks, Mr. Niven. As you know, appellants in this case have raised issues surrounding two exhibits, Exhibit A4 and A6, which are two letters written by you. I'm going to ask you to pull those up because I'm going to ask you a few questions about those.
Okay.
Starting with...
Just for the record, I believe it's exhibits A2 and A4.
Apologies. Yes, A2 and A4. Thank you. Starting with A2, have you had a chance to review this letter?
So A2 is the March 27th letter?
That's
just
right.
so that we're all talking about the same thing? All right.
Yeah, that's right.
Yes, I have.
Could you generally summarize what you're saying in this letter? General terms.
Sure. So this letter is, there's kind of two parts to this letter. There's kind of the first part, which is really about Westridge Single Family South and Westridge Townhomes South. And then there's a second part, which is about the two north projects. And the reason why there's kind of two parts to this letter is one part deals with projects that had already been submitted and were being reviewed by the city. And the other two projects, the two north projects, had not yet been submitted. The discussion in the letter is about how the city sees those projects being vested differently, given the fact that two of them were submitted already and two were not.
Thank you. Is the letter at Exhibit A2 a director's interpretation as defined in Issaquah Municipal Code 1801050?
No, I don't believe it is.
Can you expand on why that's the case?
So 1801050 basically gives the director the ability to interpret Title 18. And what it says is that anyone wishing an interpretation is to provide a written request to the permit center. And this letter didn't follow that process. This letter was a request for clarification from an applicant that was either made through an email or through a verbal request, and was issued as just my attempt at a guidance document for the applicant.
Okay, thank you very much. I'm going to turn your attention to Exhibit A4, which is the November 2017 letter,
Okay,
and ask you that same question if you had a chance to read this through and review it.
I have.
And can you generally summarize what you're saying in this exhibit, this letter?
So this letter, this letter was requested by the applicant, and just to give some context on what was happening during these kind of mid to late 2017 timeframe, is the city was in the process. We started in March, and by the time we hit November, we were still hoping that we were going to get replacement regulations adopted for Issaquah Highlands. And so I think what the applicant was asking for was what the status was of their projects with the pending termination of the development agreement, which at this time we were still hoping that we would get that done by year end, so by December of 2017. So that would have been kind of a month from when this letter was written. Unfortunately, just because the process got complicated, we didn't ultimately get those replacement regulations adopted until first quarter of 2018. But I think that's what this was a request for kind of an update on where things were given the pending end of the development agreement.
Okay, but it would be fair to say in this letter you are telling Nick Abdelnauer that Westridge Multifamily North is vested to impact fees. Is that a fair characterization?
I'm sorry, could you say that one more time? It glitched in the middle of your statement.
Well, in fairness, I glitched in the middle of my statement as well. So what I'm asking is it a fair characterization to say that in this letter you are saying that Westridge Multifamily North will be vested to impact fees?
That's what it says in the third paragraph of this letter, yes.
And in the beginning of the letter, you start out talking about affordable housing. Can you explain the connection between those two concepts?
Sure. So the city, as was mentioned earlier this morning, the city executed an amendment to the Highlands Agreement, the 9th Amendment to the Highlands Agreement, which allowed for some additional units being placed in Westridge. And part of that was an agreement from Polygon at the time that they provide some affordable housing. So the city executed a separate development agreement that basically spelled out the obligations of Polygon for affordable housing in exchange for the additional units. So what this letter is really, for me, was really saying is that the city viewed those units, the units that we had kind of worked through that development agreement, as different than the other development rights in Issaquah Highlands that weren't governed by a separate development agreement.
Okay. Is it true that the city is not treating Westridge Multifamily North as vested to impact fees when it's issuing its building permit invoices now?
To repeat your question, because it seemed like there was some multiple negatives in there. Was your question that the city is not treating Westridge North differently related to impact fees than other projects?
Let me ask it in a more clear way. Are we treating Westridge Multifamily North as vested to development agreement impact fees when we issue building permits now?
I actually don't know the answer to that question because I'm not involved in the invoicing and the permit fees that are being sent to Polygon.
Gotcha. All right, then I will move on from that. Is this letter, this November 2017 letter, an administrative interpretation or director's interpretation under IMC 1801050?
I don't believe it is, no.
Can you expand on why that's the case?
As I mentioned before, 1801050 is fairly clear in an expectation about what process is used to, excuse me, garner a director's interpretation, and that was not the process that was followed by Polygon here.
So Polygon did not submit a written request to the permit center for this interpretation?
No, they actually emailed me a draft of this letter and asked me to sign it.
And that email didn't go to the permit center?
No, it came directly to me.
Right. In the first paragraph of this letter, you refer to your March letter, which is Exhibit A2, as an interpretation. Can you explain what you meant by that phrase?
So that was, you know, I probably did not spend enough time scrutinizing the wording of that particular sentence that was proposed by Mr. Abdelnour in his draft letter for my signature. I don't view it as a director's interpretation. As I mentioned earlier, I believe that the March 2017 letter was intended as guidance to the applicant, and it was my best understanding of the circumstances at the time.
Would it be fair to say that you interpret the code in lots of types of different written communication, email, letter, memo, what have you?
Sure. I think all the planners do, and the engineers and the building officials. So I think we all do as staff need to interpret the code to make decisions.
Is each one of those documents that interprets the code a director's interpretation under IMC 1801050?
I don't believe so, no.
I would like to point you to City's Exhibit 30.
Yes.
You have that up?
Yes.
Okay. Is this a director's interpretation under IMC 1801050?
Yes.
How do you know?
Because they made the request through the permit center. Staff spent a number of weeks kind of compiling the information to ultimately render a decision. It was reviewed through the city attorney's office and then ultimately executed by myself. So it followed what I view as this more standard practice of getting a director's interpretation.
And not to beat a dead horse, but does it say director's interpretation at the top?
It does.
It does. I actually had a question under authority. It says section 1.5 of the City of Issaquah Land Use Code. And then it does a block quote. Is that the same section as IMC 1801050?
Yes, I believe this excerpt was from the original ordinance in 1996, whereas what's in current code has been updated to reflect some of the current terminology. But yes, it's the same language.
Thank you. And you mentioned that you consulted with a city attorney before writing this document. Did you do so before writing the March or November 2017 letters at A2 or A4?
I did not.
Have you ever issued a document that you would consider to be a director's interpretation under 1801050 where you didn't have a written request to the permit center for a director's interpretation?
No, I would direct that individual to make the request through the permit center.
Okay. I'm going to move on to some questions about the fees themselves and the city's process for that, unless it looks like the hearing examiner has some more questions.
Just one question, I guess, Mr. Niven. In your view, you know, is it possible for an applicant to request a director's interpretation under 1801050, an independent standalone determination by the director on vested rights? Is that something that's possible for an applicant to do, or does it have to be part of a permit ultimately?
So I'm not an attorney, and I would definitely consult the city attorney on that question. I believe that since the city code covers vesting, and an applicant, if they had questions about relativity in regards to the vesting language that's in the code and would seek an interpretation on that, it seems like that falls under that umbrella of 1801050. But, again, nobody has asked for that during my tenure as director of this department. If somebody did, we would start the process, and likely the first step of that process would be to loop in the city attorney into that request.
Great. That was my question. Thank you.
If I may, I'll ask two clarifying questions based on the hearing examiner's question. Mr. Niven, you just said to your knowledge, no one has ever requested that. To clarify, you're saying no one has ever requested a director's interpretation on vesting specifically, correct?
Yes.
Gotcha. But for instance, C30, which is not about vesting, but that is a director's interpretation, correct?
Correct.
Okay. And that was issued in response to a written request?
Correct.
Okay. Is a director's interpretation under IMC 1801050, is that appealable to the hearing examiner?
That would be my understanding, is it's an administrative decision that would be appealable to the hearing examiner.
Great, thank you. Okay, now I will shift gears to the actual impact fees themselves, and I'm going to ask you some questions about the impact fees and the administrative adjustment process. So in this case, as you may know, Westridge is arguing that they shouldn't be subject to full impact and mitigation fees. Can you respond to that argument and tell us a little bit about the process for requesting an administrative adjustment of fees?
Sure. City code, and it's I don't have those citations directly, but what I would tell you is for traffic impact fees, park impact fees, fire impact fees, mitigation fees, school impact fees, the code envisions a process for both allowing for a credit and for allowing an adjustment. And so a credit, for an example, would be if an applicant were to have maybe built a roadway or provided a park. There's provisions for adjusting the impact fees based on some sort of kind of asset donation or construction. An adjustment is more envisioning, for example, I'll give you an example, like traffic impact fees are based on traffic generation rates from the Institute of Traffic Engineers manual on traffic generation, which is kind of normalized over a number of different projects. And if you were to come in with a specific project where you knew that the traffic generation would be different, you could make the argument that you should pay a lower traffic impact fee based on your specific case. So the code allows for both of those things to happen, both accrediting if there were things built or provided that satisfies an impact, or an adjustment based on kind of specific characteristics of a project.
Great. Thank you. There's a lot of information in there, so I'm just going to break it down a little and make sure I understand everything you're telling me. You mentioned both credits and adjustments. Those are two separate processes. Do I have that right?
Those are, and if you need me to find the codes for each of them, I could. It would just take me a bit to pull up the city code.
That's fine. I've listed in the briefing. Mr. Examiner, would you like us to summon those code citations?
Got them right here.
Great. For an impact fee credit, Mr. Niven, is it your understanding that the project contributed has to appear on a project list? a TIF list or something along those lines?
Right. So, sure. So if it was a traffic project, it would need to be on the city's TIP. And if it was, say, a park project, it would need to be on the city's CIP and part of the funded list, because that's what's used to generate the impact fees themselves.
Okay, and the adjustment process is a little more flexible. Doesn't have to appear on a tip list, for instance.
Exactly. That's my understanding.
Did Westridge, or I keep referring to them as Westridge, but I mean Polygon or Taylor Morrison, did they ever apply for an impact fee credit or impact fee adjustment under these code provisions?
Not to my knowledge.
If an applicant were to apply for a credit or an administrative adjustment of fees, what would that application look like? What does an applicant typically do, and what do we typically require them to do?
So typically, what we ask for is a letter to be submitted to the permit center, and generally it would identify the fee that was being requested to be adjusted or credited, and the rationale for why the city should either credit or make the credit or the adjustment. So it's basically a letter submittal and then documentation.
And how would the city typically respond to that letter application?
We would ultimately write a decision, a written decision, after we'd evaluated the request and whatever background information was submitted.
Would that final decision be appealable to the hearing examiner?
I would expect it would be as an administrative decision.
Okay. Excuse me, give me one moment. I'm going to think about this. If Polygon were to apply for an administrative adjustment and offer the argument it's offering here, namely that 25 years ago we agreed they were fully mitigated, and that was their rationale for an administrative adjustment application, would we agree to write off 100% of their fees? Can you say point blank that that's the case?
What I would say is, if they were to make that case, we would consider whatever rationale they would give for 100% credit or reduction in fees, and then we would make a decision. So is it possible? It's possible. I think there would definitely be a lot of factors that would be weighed before a decision would be kind of issued on that request.
Okay. Can you expound on some of the complicating factors you would have to look at in assessing an administrative adjustment request?
An adjustment or a credit, or both?
I'm specifically asking about an administrative adjustment.
So an adjustment, so typically, what would be used for an adjustment consideration would be, as I mentioned earlier, project-specific factors that would decrease the impact beyond that of maybe a comparable project somewhere else.
Okay. In this case, Polygon's predecessors in interest built some mitigating projects and gave some cash essentially to the city under the development agreement. How would the city go about assessing the value of those contributions that were made in 1996 dollars? Would we convert it to 2020 dollars? How do we deal with that inflation?
Since nobody has made that request yet, what I'm going to tell you is we would have to come up with our rationale for a response. Factors that could be included would be kind of devaluation of improvements provided, city costs for maintenance of those improvements over the past 20 years, different impacts that might be relevant in 2020 that weren't in 1995. There's a lot of different factors that I think the city would need to weigh in that kind of decision process.
Okay. My understanding is that when the city executed this development agreement and agreed on mitigation back in the 90s, we did something for traffic impact fees called an internalization credit. Can you explain what that was?
Sure. The EIS for Grand Ridge, which was Issaquah Highlands before it was called Issaquah Highlands, basically made some assumptions in terms of the mix of land uses. So, by developing not just a residential project, but including both commercial and retail, the expectation was that the trip generation rate outside of the Highlands would be lessened, and that more trips would be internal. And my recollection from a really distant memory is there was a 12% credit on total trips that was given for an internalization of trips based on land use.
Okay. Did the city's assumptions about internalized trips prove true 25 years later?
And clarifying for me, when we're saying, so my sense of what is being thought of in terms of this internalization is that I live in the Highlands and I work in the Highlands, and because of that, my traffic stays in the Highlands. It's internalized such that my impacts on the infrastructure and the rest of the city are less. Is that the basic concept?
That's the basic concept. And you get your groceries in the Highlands, so you don't ever leave. Small bubble.
Got it.
Yeah.
Okay. Sorry.
I'm going to enter an objection to the line of questioning, at least without some foundation. Mr. Niven has not testified as to whether he's a traffic engineer or administers the current currency system, anything like that. So I'd ask for foundation.
I mean, I note the objection in terms of his role at the city. I think he's got a general understanding, of how all of this works. But so I'm going to let him continue. But I note the objection.
Thank you, Mr. Examiner. So my question was, did this internalization assumption prove true? And feel free to answer that question with your level of director expertise rather than engineer's expertise.
So the story's not done, right? We have a number of projects that are still remaining to be built on, both in Westridge and on Shelter Holdings properties. So given where we are now, I think the belief is we're generally residentially high, given the amount of commercial and retail spaces that has been built. Retail kind of is at about maybe half of what the total entitlement was for Issaquah Highlands, and commercial space, the hospital was built, Pro Alliance was built, there's an office building built by Fort Blakely, but generally speaking, the major employer that was envisioned at one point, it was Microsoft. That hasn't happened yet. And so if you live in the Highlands, there are a few job opportunities where you could work and live in one place, but most likely most of the residents commute out of the Highlands. That's my intuitive understanding. Again, I haven't done a traffic study. I'm not a traffic engineer, but that's my intuitive understanding of where we are right now in this given time.
If you were to receive a formal request for an administrative adjustment, would you consult your traffic engineers?
As it relates to the traffic impact fee, yes.
Great. So I've asked you about $1,996 versus $2,020 and the internalization credit. And are there any other sort of issues out there that you can think of that we would want to look at in an administrative adjustment application?
Yes.
Can you explain what those are?
I would. So no, I would rather not. So I have not, there's not been a request made. I do not want to box us in. There's a process to be followed for an adjustment and a credit. And, a lot of it relies on the case that's being made by the applicant. And since none of that has happened and the city has no precedent as it relates to what Polygon or Taylor Morrison might ask for, I would rather not give a finite list right here this morning.
Fair enough. If you give me one moment to review my notes, I think that might have been my last question. I have no further questions. Thank you, Mr. Niven.
Thank
Before I hand Mr. Niven over for cross-examination, I guess my question would be, I don't know the code well enough, and I think there's clearly different areas of the code that deal with different things, and impact fees are sort of all over different sections of the code. If this applicant wanted to go through that process of requesting an adjustment or credits, is it too late at this point? I mean, are there deadlines that have now passed? I mean, they've pursued a sort of appeal it outright process as opposed to seek an administrative adjustment process. I'm just curious if by doing that, they've missed the boat at this point on potentially using that other process. I just don't know what the answer is. Do you happen to know that, Mr. Niven?
My answer is I don't think it's too late. I think that there isn't a time limit in terms of, the code also talks about, you can pay your impact fees to get your building permit under protest,
Right.
with an understanding that then it could get resolved afterwards and the city could ultimately refund any judgment over overpayment. So my belief is I don't think they've missed the boat, so to speak, if they still wanted to pursue that as an administrative option.
Great. Thank you for clarifying that for me. Ms. Koloshkova, this is now your opportunity for cross-examination.
Thank you. I might ask for a 2-minute break. I do have a few questions and I could use a personal.
It's been 90 minutes. Why don't we why don't we come back at 10:40? That gives us 8 minutes. Is that enough?
I can run fast down the hall.
We'll come back in approximately 10 minutes, okay? Almost ready. Okay. Duana, are you ready to go? Candy, if you can start recording. Oh, there we are. And we'll go back on the record. We were just about to turn Mr. Niven over for cross-examination. So Ms. Goloshkova, your witness.
Thank you, Mr. Examiner. Good morning, Mr. Niven. We've met before. It's nice to see you again.
Nice to see you again.
I am fortunate that I do get to go to my office, and I must apologize to everyone that I have mood lighting. I have a beautiful wall of windows in my office, but this time of year, the sun goes very much south. So I'll try to.
Yeah. I was holding, until this week, I was holding these hearings in my work shed, and the lighting was pretty great. But now it's like 40 degrees outside, and I started my garage.
Exactly. Yeah.
Change my system. So.
Crazy days. I must say, I do love being able to do these though by video when we don't have a bunch of geotechs and such, because it's wonderful. Thank you for it. It makes life very easy. Mr. Niven, I have a bunch of questions for you, so I'll ask you to bear with me. You provided some testimony, and it may jump around a little bit, so I apologize. I'll do my best not to, but you provided some testimony about your understanding of Issaquah Code Section 1801050. Can you pull that code section up in front of you, please?
Sure, give me just a second.
Thank you.
Okay, I'm there.
Okay. So if you would please read the second sentence for us out loud, starts with the Development Services Director.
Underneath Section A.
Under Section A, thank you.
Okay, absolutely. So the Development Services Director or his or her designee shall have the authority to interpret this code.
Okay. And then after that, it talks about if an applicant wants an interpretation, this is how the applicant asks for it, correct?
Correct.
So it's you as the director that interprets code, not the Public Works Director or the mayor or anybody else, correct?
Under Title 18, yes.
Under Title 18, thank you. Yes, I guess other sections, we talked about it, for example, maybe concurrency might fall under the city engineer, for example. Is that correct?
So concurrency is actually in Title 18, so it's mine. But we could use a different example, like dealing with the water system.
Okay. And that would fall to which entity in the city, which individual in the city?
Public Works Engineering Director, which is now engineering and operations have been consolidated, so there's a single Public Works Director.
Okay. Okay. So when you, and now I'm going to take some of that and I want to turn to exhibits A2 and A4. I presume you still have those in front of you.
And I'm going to hop in with one follow-up on that exact line of questioning, because we just talked about Title 18 versus other titles, But in terms of the issue of vested rights, that ultimately is your determination applicable to all sections of the code or just Title 18, Mr. Niven?
Just to Title 18 is my understanding.
Okay.
So so Title 18 is a land use code. So anything that is related to, land use permits or interpretations coming through Title 18 would be me. I believe Title 16, I think the building code specifically says the building official has authority there. But I think the city code overall gives different authority to different titles to different directors.
Even in terms of vesting.
Well, I don't believe. Well, I haven't done a code search, Mr. Hearing Examiner, so I'm not sure what other titles actually include language relating to vesting. I know specifically 18 does.
Okay. So, I mean, in 1801050C, vested rights, it says all city determinations regarding vesting shall be made only by the Development Services Director in consultation with the city attorney. But your view is
Look at that.
only Title 18, or that's the whole code? I would think it.
That says the whole code.
Okay, just wanted to make sure I was tracking, so I apologize for interrupting. But Ms. Glasgow, I'll turn it to you.
Thank you, Mr. Examiner. And I think I have a couple follow-on questions then before we turn to the letters, because I appreciate that clarification. And I do think we should then also clarify under Title 3, for example, under Chapter 3.71, which is traffic impact fees, the reference to director in that chapter, am I correct, Mr. Niven, refers again to you as the Development Services or Economic Development Director, correct?
Correct.
Okay.
That's my understanding.
You also are entitled to administer, review adjustments, et cetera, under various sections of Title 3, including 3.71.
That's my understanding, yes.
And I can say 371.020H says that the director is Development Services Director.
And
so
I suppose we could go through the other sections of 3, but would it be fair to presume, Mr. Niven, that for purposes of impact fees, director is going to be referring to you when it comes to, for example, parks and open space also?
Yes.
Okay. And I believe you testified in response to a question from the hearing examiner that you would be the one who reviews adjustments to fees. For example, under, was it 1871-080?
You mean 371.080?
371-080.
I actually followed you, which was scary. So
no, I think we're nerding out here.
Yes, both credits and adjustments would fall into my basket.
Okay, and I believe also you maybe implied, so let me ask you directly, in looking at 371-080, there's no particular process or time frame that applies to fee, your review of fee calculations under Section A, correct?
What I can tell you is what we have done in the past. I'm
actually asking about code. I'm not asking about what you've done in the past. I'm asking if I'm reading code, is there a process that one needs to go through or a time frame?
So the process is a written request to the permit center, and the time frame, as I was going to mention, is we typically contact the applicant back and let them know how long it would take to get a decision rendered because it's not covered in code.
I think we're talking about 2 different code sections, and that might have been my fault because I was referring to Title 3 and, for example, 371-080, the impact fee adjustment section. which I
Yes.
believe you just testified you also have authority over. Does that also have to go through a application process to the permit center?
I wouldn't call it an application process. What I would call is a letter submitted to the permit center.
And where is that requirement in code? And under Title 3 or Chapter 371, which is the one we're looking at.
So that procedure isn't specifically in this code, but that's how we receive formal requests in the department. So I don't know how else that would happen. And if somebody sent me a direct request, I would ask them to submit a letter to the permit center.
You would, okay.
I would.
Even though that's not, so it's specified in 18, not specified in 3. If someone contacts you, I'm summing up so I understand what you would do. You would tell them, okay, you got to go to the permit center.
That would be my suggestion, is that they submit a letter to my attention to the permit center, so that because that way it gets date stamped in. There's a lot of reasons why that's the procedure I would want to follow. But that's what I would ask to have happen.
Okay. But that again is not reflected in 3.71 as opposed to Title 18, correct?
Correct.
Okay. Just making sure we agree at least on what code says. Okay. So then coming back to these two exhibits, A2 and A4, for which you provided quite a bit of testimony. Can we agree these are letters that were signed by you in your capacity as the department director, correct?
Yes.
Okay. And have you remained department director at all times since?
Yes.
Okay. And were you were department director then during the course of the city's termination of the development agreement and adoption of the replacement regulations, correct?
Yes.
And is the record correct as it stands now that you never provided Polygon any follow-up written letters addressing these topics after the date of A4, or are we missing any written documents?
I don't recall any documents that would have kind of countered or provided updated information to Polygon since the November 22 letter.
Okay. You testified to Ms. Hambley, I believe it was about Exhibit A2, but I'm not sure that Polygon had written up this letter or asked you to sign this letter. Was that your testimony?
My testimony was about, just to make sure we're talking about the right exhibit, the November letter was a draft copy that was submitted to me for signature by Mr. Abdelnour. The March letter was, as far as I remember, drafted by myself.
Okay. And do you agree that the purpose of these letters was to explain to Polygon the statements that were written in those letters as those would apply to their various applications?
I believe that there were a lot of questions about the termination of the development agreement and the adoption of the replacement regulations. And so I think the letters were intended to provide my understanding about how the city would view those applications under those circumstances.
Okay. And weren't these letters provided after you and Mr. Abdelnour emailed about how things such as impact fees and mitigation would be handled after the development agreements expired?
So I don't recall. I'm not doubtful that there were conversations with Abdelnour about those types of things because they have significant impact. What I would want to just mention is that in 2017, both in March and in November, the administration was recommending a very different vesting provision than what ultimately the city council adopted in the replacement
I'm
regulations.
talking about the letters right now. We can talk about that separately if we want, but I'm talking about these letters and the purpose of these letters. So whether there was correspondence between you and Mr. Abdul-Noor leading up to these, or if these were just sort of out of the blue, nobody'd asked for them, you just kind of came up with them one day.
And that's not what I said.
Right.
I actually said that the second letter was a request from Mr. Abdul-Noor for me to sign, following up on a number of emails back and forth between Mr. Abdul-Noor and staff. So,
and it is correct, isn't it correct that that was following up on emails asking you to address the topics in this letter, which include impact fees and how those would be handled?
I don't recall the content of those emails.
Okay. I am going to I'm going to try to share my screen. So please bear with me. Make sure I share the right. I'd like to share and enter in as a rebuttal exhibit. This should be an email string from March 2017 between Mr. Niven and Mr. Abdul-Noor. Is this showing up on the screen? Because my screen, when I share, it shows this tiny, tiny page and nothing else.
It's a tiny, tiny page.
Okay. Mr. Examiner, I'm not sure what to do here in order to try to share the screen. I'd like to request that this email be viewed and entered into the record, and I don't know how to do that.
May I make a suggestion?
Yes, please.
So Keith, you're saying you're having a hard time seeing this?
It's really small.
Yeah.
Like
If you
really small.
If you hover over the toolbar that's kind of on the left, it's a shorty little toolbar in the middle on the left. There's a magnifying glass that will let you zoom in.
I don't have that on my screen, but
I'm in a better place. Even
I have it separately as a document. Mr. Niven, can you confirm that I have shared a document that has my name, Duana Koloshkova, at the top, and the next line is from Nick Abdul-Noor, and it's dated Friday, March 10th at 11:14 a.m.?
Yes.
Okay. All right. I have shared the correct document. Thank you, Ms. Hambley. I will work with the city later to figure out why it seems like on my share, it doesn't allow me to blow it up.
Joanna, are you using a web browser version of WebEx or the application?
I'm using the web browser, so that might be.
That's it, yeah.
Is it? Okay. Well, in all events, I think we all have the document in front of us.
And just one sec. So, Ms. Hambley, do you have any objection to this being admitted as an exhibit of the record?
I'm happy to lay some foundation if she needs.
I don't have any objection to it being what it appears to be. I mean, it appears to be an email chain between Nick Abdul-Noor and Keith, but I do, at the moment, I don't see what it's in rebuttal to or rebutting, but I will give Ms. Koloshkova a chance to show that and might object in a few questions.
Thank you much. I'd like you to, Mr. Niven, please go to page 2 of the document.
Well, you're driving.
Oh, boy.
We can actually drive. It's weird. You should be able to.
Oh, really?
Stand up and down on this.
Oh, sweet. All right. Sorry. Apparently I can drive.
Oh,
okay.
Thank you. Good. Okay. Because I can't. That's
starting with the March 10.
Okay. Page 2. There's in the middle of the page some text following an email from Mr. Abdul-Noor to you dated March 10th at 11 a.m. Do you see that?
Yes, ma'am.
Okay. And so in there is a discussion. Can you please, it's probably just easiest if you could read it aloud, the short text from Mr. Abdul-Noor's iPhone.
Sure. So what it says is, okay.
I'm sorry, I'm going to interrupt. If the parties are amenable, could I just have a few, I haven't seen this, could I just have a few minutes to read it myself and then we can proceed with record entering?
Sure.
Thank you.
And there's not much more text beyond this.
I'll be quick.
I haven't read it either, so.
Somebody's scrolling like crazy.
That's me.
Okay.
Oh, I'm sorry.
That's okay.
Thank goodness, this is the main box.
It's weird. It's like we all have the steering wheel at the same time.
So that would be fun.
Not a great system.
Well, I can't even see it unless I will let you all know this is short. I won't belabor this testimony.
Okay, I'm ready for you to continue, Ms. Kloshko.
Thank you. And now that everybody has read this, Mr. Niven, I'm going back to the text on page 2 of the document from Mr. Abdulnur to you. Do you see that text?
The text that starts with "okay" on another note.
Correct.
Yes, I do.
And particularly the discussion of how fees would be handled if the DA expires. Do you see that discussion?
I do.
Okay. So you did receive correspondence from Mr. Abdulnur asking you to review how fees would be addressed when the DA expires. Isn't that correct?
That is what this email says. Yes.
Okay. And then after this email, did you continue to correspond with Mr. Abdulnur through March and obviously all the way into November of that same year?
Yes. So that would be my guess.
Okay. I'm going to just stop sharing this. I guess before I proceed, I would like to ask that this email string be entered into the record as
I believe would be at A22, I believe.
Thank you.
And
I have no objection.
okay, so we'll admit this as exhibit A22.
As I indicated, that was going to be relatively painless, I think. So, Mr. Niven, we then had the letter you stated you wrote in March as Exhibit A2, and then again, Exhibit A4, which addressed the fees that Mr. Abdulnur asked you to address, correct?
So no, I'm going to ask you to pull that document back up again if you could, because what that document is actually asking Mr. Abdulnur to do is to provide us with, and if I got to zoom it back in, darn it. Sorry.
Same with me.
Okay, if you see underneath, sent from Nick's iPhone, underneath it where I say on March, oh, whoa, don't stop moving it.
Sorry.
Oh, darn it.
I'll scroll back.
Where it says, okay, stop moving it. Where it says, have asked both Gary/Tia and TriMet to draft a certificate that we should issue that would recognize your credit, have gotten nothing. What that references is Shelter Holdings and TriMet, who own the commercial property in Dallas. And what I was suggesting for Mr. Abdulnur was that one of you, whether it was going to be Polygon or someone else, actually attempt to ask for this credit through a process that we could then apply to everybody. So what I was asking for was not to draft the letter of 22 November. It was to come up with this model where we could address credits on impact fees for all projects. So I just wanted to make that point because I think it's an important point because what the conversation that was happening through this email chain was not to get to this letter. This was an outcome that I was not really interested in. So I just wanted to say that.
Okay. But I'm going to stop sharing just so I can get my screen large again. Okay, now I can see you again. But you did then and to be clear, the shelter projects you're referring to, can we agree those are separate projects that are separate from the polygon projects?
They are separately owned, yes. Okay. I think there's some similarity in issues, but yes, separately owned and being separately discussed.
I would not ask you to speculate on issues. Those are not before this hearing examiner in this case, and I guess I would.
Not in this case. That's all we're going to say.
I will. We have nothing to do with that. But you ultimately then, in your A4, Exhibit A4, provide, as requested, that impact fees, I quote, set forth under the existing Issaquah Highlands Development Agreement, that such vesting is not affected by the pending expiration. That's, and I'm just looking at Exhibit A4 where you make that statement.
Correct.
Okay. Now go, if you would, back up in A4 to the first paragraph, last sentence. Could you read that sentence for us?
Sure. This letter is supplementary to the correspondence of March 27, 2017, which provided you with an interpretation of vesting provisions related to your Westridge projects in Issaquah Highlands.
So when you said this is supplementary to your prior interpretation, you didn't mean that you were interpreting code?
What I would tell you is that language was provided by Mr. Abdelnour, and unfortunately, I didn't rephrase that before I signed this letter.
I guess I'm confused. You asked Mr. Abdelnour to write a letter for you, and then you didn't read it. You just signed it. Is that what you're telling us?
That's not what I said. I said I didn't rephrase that particular sentence. I would not have used the word interpretation if I'd have spent a little bit more time thinking about it.
But you did use that, and you did have time to reflect on that letter for almost 3 years, and you've still never provided anything in writing to address your statements in this letter. Isn't that correct?
That's correct.
Okay. Now, you stated you never consulted with the city attorneys when you were writing these letters. Is that correct?
That's correct.
When was the first time you did speak with your city attorneys regarding the Westridge projects?
I don't remember.
Did you ever speak with your city attorneys about the Westridge projects before today?
Yes, it probably happened during the Shelter Holdings depositions at the Development Commission. These letters were brought up then.
When you speak with your city attorneys, do you then report those conversations to applicants?
It depends.
Now, I guess, so the last correspondence from you is Exhibit A4 in November. And I hear you now asserting that Polygon should have asked you for review of impact fees under the section 371080 to see if the city would make an adjustment. Is that correct?
That's correct.
But why would Polygon ask for an adjustment when the last correspondence it has from you states that impact fees are not going to be affected by the expiration of the development agreement?
Because the council changed the vesting regulations in the replacement regulations for Issaquah Highlands than what was being proposed by staff in November of 2017.
And that was after you issued this letter. And
It was.
where in the replacement regulations did they address impact fees for the Westridge North projects?
Sorry, I'm pulling up city code. For Issaquah Highlands, IMC 1819B as in boy .280 is section titled vesting of permits.
Okay.
I believe that is the code language that changed between November of 17 and the adoption of this ordinance.
I apologize. Could I have the witness repeat that code citation?
18.19B as in Bravo .280.
And this code section addresses building permits, long plats, short plats, development agreements. Is that correct?
That is correct.
Okay. Anything else you want to point to in code?
Not unless I'm responding to a question.
Okay. So let me ask you this. Actually, I already asked you that, sorry. Were you, Mr. Niven, were you the development director in Issaquah at the time that the development agreement was originally executed, I believe in 1996?
No, I was not.
Do you know who the director was at that time?
So the development agreement for Issaquah Highlands was actually not administered by the planning department. It was administered by the city at the time, had a group called the Major Development Review Team. And I didn't join the Major Development Review Team until 1998.
Okay. And then after you joined and during the course of various negotiations related to Issaquah Highlands, isn't it correct that the development agreement was amended several times?
It is.
And those amendments would have addressed changes in different types of density choices between residential and commercial that the council was making. Is that correct? At least some of the amendments, maybe not all of them.
So there were 9 amendments, as you know, because your client was the last. So the original entitlement had a certain amount of flexibility in it. There was the ability to convert some of the commercial to additional residential units. So that was allowed without having to execute a council adopted amendment. So the amendments that happened, I don't believe changed the entitlement at all. There was some adjustment done under the provisions of the development agreement, but nothing through a major amendment that I can recall.
Okay. But the council could have covered that if they'd wanted to during the course of those different amendments. If they needed to, I guess I should say.
They could have.
I believe you testified you're not involved in invoicing of building permits. Is that right?
I try not to be, so no, I don't.
But that department does fall under your purview. Is that correct?
So it does. So my understanding is invoicing happens through our permit technicians, and the permit technicians report to our building official. And then the building official reports to me, so it's kind of like a third cousin.
So let me ask you, this is a broad question. During, maybe I will say the first half of 2020, did anybody ever talk to you about invoicing of building permits for any of the Westridge North projects?
I'm going to object just because I think this is going outside the scope of direct, but perhaps it'll loop back in. But if we're getting into nitty gritty of when building permits were issued and so forth, I'd say that's outside the scope of direct.
I don't know quite where we're going. I'm going to let it move forward. I note the objection, but so go ahead, Ms. Koloshkova.
So my recollection is that at some point, and I can't remember when, the building official did mention to me that they were having issues with invoicing of the permits for Westridge in terms of the fees. So I was made aware of it through a verbal accounting by our building official at some point during the first half of this year.
Okay. Did you ever reach out to anyone at Polygon after that discussion?
I don't think I did, no.
Okay. I have no further questions for you at this point. Thank you.
Thank you.
Any redirect, Ms. Hambley?
Yeah, I do have a few questions on redirect, if that's okay. First, I'd like you, Mr. Niven, to pull up, just by way of example, the administrative adjustment provisions in IMC 371080, which is, I believe, pertaining to traffic, but we use it as an example and the language is all pretty similar.
Okay.
And I actually accidentally just navigated away from it, so get the email.
Sorry, which section one more time?
IMC 371080.
371080.
Great. I believe Ms. Koloshkova asked you whether this code provision requires a letter to the permit center. Do you remember that question from her?
I remember we discussed that, yes.
And I believe you testified that you typically require a letter as a matter of practice. Is that correct?
That's correct.
Okay. Looking at this actual code language, can you read aloud subsections 1 and 2?
Sure. So underneath A, I assume, since those are the only 1 and 2,
Yes.
number 1, the applicant demonstrates, sorry about that, the applicant demonstrates that an impact fee assessment was improperly calculated, or number 2, studies and data provided by the applicant demonstrate that one or more of the factors used to calculate the impact fee may not be appropriate for the particular use.
Okay. Would it be fair to characterize this as placing the burden on the applicant to show they're entitled to an adjustment?
You could read it that way.
Okay. I would like to turn to the Rebuttal Exhibit C21. If you'll give me a moment, I have to pull that. Is that in my email now, Ms. Koloshkova? Yes, it is. Found it.
Wait, which exhibit?
Oh, I'm sorry. Rebuttal Exhibit A22, which is the email chain we had up on the screen. And I see A21, but I'm actually not sure I have A22.
We're getting it sent around right now.
Good. Oh, I will, if someone else can, I am sending it as well.
Great. If you could send it, and if you could send it to Keith as well, I'm not going to pull it up on the screen again because that made me busy. I'm just going to have us both look at it at our own screens.
Can I get Keith's email?
It's Keith N at issaquah.gov.
A22. So I'm going to add Connor on this too. Go. It's on to you all. And again, I really apologize for not understanding that. Actually, I am in an app.
Oh,
So I will be interested to see what it looks like when you share, because I think I was the first individual to share documents. So
well, now my little pain is gone too. Oh, well, because I'm not sharing. Duh.
So I do have the email open. So if we want to proceed,
Thank you.
I'm ready.
Okay. I'm not going to share this unless the hearing examiner would like me to. I think we all have it up outside of this app.
I've already memorized it, so.
Okay.
and I've emailed it around now.
Okay. Well, after all that, I'm going to ask one measly little question about this, which is, Keith, I just want to confirm that your response, which is kind of mid-chain spanning page 1 and 2, and then a little further up, you're suggesting that Polygon apply for some sort of credit or adjustment or something like that. Was that your testimony?
That was my testimony, yes.
Okay. So you're not asking them to go through the letter writing process that ultimately resulted in exhibits A2 and A4?
I think so. No, I think what was envisioned here was that, and you can see my next email above. Think about the concurrency certificate or water availability certificate as a model. What I was envisioning was ultimately having them make a request for a credit, having us, the city, issue some sort of certificate that would be that credit or adjustment later. That's what was being discussed through this email exchange.
Great, thank you. Okay, turning to A4, which is your November 2017 letter. Ms. Koloshkova asked you some questions about that word interpretation in the final sentence of the first paragraph. And I think we would address this on direct a little bit, but can you clarify, do you interpret the code in situations other than a director's interpretation?
Yes. So there's, I think there's a different level of formality with the director's interpretation. As I mentioned earlier, if I would have kind of scrutinized this language a little bit closer, I probably would have replaced interpretation with guidance, because I think it's a better representation of what that March letter was.
But for instance, if you were writing an email explaining ambiguous provisions about setbacks, in a casual sense, you're interpreting the code.
Yes.
Okay. But that doesn't make it a director's interpretation.
I don't believe so.
Okay.
The hearing examiner might disagree, but I don't believe so.
That's what we'll find out when he issues his decision. Ms. Koloshkova asked you why her client would have had an incentive to seek an administrative fee adjustment if they'd already gotten your letter from 2017 on vesting. And I wanted to ask you, are you aware of when the first building permits were issued in this case that Polygon appealed. It's okay if you don't know. I'm just asking if you do know.
I don't know.
Okay. I think we have that in the record. Ms. Klosheva asked if the council would have had the ability to modify or amend the development agreement and change the commercial residential mix. And I believe you testified that yes, they could have.
Yes. Sorry.
Okay. That's all right. Could they have done so unilaterally?
No. So the terms of the development agreement basically gave predictability on the entitlement to the master developer, and any modification that wasn't kind of health safety related had to be kind of jointly brought forward by the master developer and the city.
And to be clear, right now, we're discussing the bigger, long-standing Grand Ridge, which later became Highlands development agreement, which is now terminated, but not the development agreement that has been referenced in, I think it's A2 or A4. Is that right?
Yes.
I just want to clarify, Mr. Examiner, when you say A2 or A4, A2 and A4 are the letters from 2017.
I know, and there's reference in these letters to a new agreement that Polygon independently created with the city about its properties that are related to affordable housing. That's not the agreement we're talking about. I just want to make sure I'm tracking what agreement. The agreement, if we're just generally talking about the DA, we mean the big Issaquah Highlands, formerly Grand Ridge DA. We're all on the same page there.
I can say
That's what I'm talking about.
Okay, I just want to make sure because, again, there's a lot of exhibits, a lot of things, a lot of balls in the air. I'm just trying to make sure I don't lose track.
Sure. And just to pull on that thread a little bit, Mr. Niven, I'm going to point you to Exhibit A3 and have you take a look at that. Or I can just tell you, I believe it's the standalone development agreement that hearing examiner just referenced. Okay. And if you would you read the very first introductory paragraph of that agreement on page app 000010. So it's a couple pages into the start of the exhibit, that very first paragraph.
So the first whereas paragraph?
No, the paragraph above the recitals.
Oh, I'm sorry. Underneath the resolution.
I'm looking at a page, app 00010, it says Exhibit A at the top. It has a title that says Development Agreement going on Northwest, and then it has a little paragraph, and then it says recitals.
So page 5 of the Bates number is 10, but page 5 of that exhibit.
That's what I'm looking at. And I can share a screen if that's helpful.
No, I'm almost there.
Helpful.
Okay, so Exhibit A, that document.
Yeah.
And so you want the paragraph before the recitals?
That's what I'm looking for.
Okay, I'm there. All right, so it reads, this development agreement in parens agreement is entered into effective on the date of the last signature below by the City of Issaquah, parens City, and Polygon WLH, LLC, in paren Polygon Northwest, to amend the Issaquah Highlands development agreement as described below.
Is it your understanding that that reference to the Issaquah Highlands development agreement is referring to the big development agreement from 1996?
Yes, it is.
Okay. I have no further questions. Thank you, Mr. Niven.
Okay. Well, we just lost. That might be a perfect time. No, I was going to say, I think we just lost Mr. Niven, but
I just came back.
he's back. Okay. So then that, I believe, covers Mr. Niven's testimony. Your next witness then, Ms. Hambly?
Sure. I'd like to call Lucy Sloman, and I'll just note it's 11:28. I think this will be fairly narrow, so I think we might actually be able to finish before a lunch break, but if the hearing examiner wants to break, we can find a pause for that.
Yeah, why don't we start and then we'll, as we go, we'll figure it out.
Okay, sounds good.
Ms. Sloman, nice to see you. Do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you.
Hello, Ms. Sloman. Could you please state your name and professional address for the record?
Lucy Sloman, 1775 12th Avenue Northeast, Issaquah, Washington, 98027.
And what is your role and title at the City of Issaquah?
I am Land Development Manager, which means I'm in charge of planning and engineering, current planning and current engineering permitting for development.
And how long have you been in that role?
Since 2012.
And before that, what was your position?
Under the Major Development Review Team, or MDRT, that Keith mentioned, I was a planning consultant from 1996 until 2012.
Could you give us just some background on your involvement in the Westridge projects?
So I've probably had, at a high level, two roles. One is, since I'm managing the planners and engineers who are doing, reviewing those permits, I'm overseeing their work. And then in the case of certain permits, such as Westridge Single Family North, I was the planner on the land use permit.
Great. Ms. Sloman, were you present for Mr. King's testimony this morning?
I was.
Did you hear him testify that the city did not impose impact fees on 6 building permits for model phase homes for Westridge Single Family North?
I did.
Could you explain a little bit about why that was the case?
Well, as I understand it from staff, they thought there was a 2-phase billing process or invoicing process, and that the first bill did not include that, and that it would be included on a later bill.
And the city did not issue a second bill for those?
I think there was a decision that that we were not in a position to do that second billing.
Okay. Turning to, this is going to go very quickly, so I just have 2 other little issues to ask you about. My next question is, are you aware of the Westridge projects ever having received affordable housing money, cash funding from city, county, state, or federal government?
I am not aware of that.
Okay. Just give me one moment here. So you have familiarity with the broad constellation of Westridge projects, single family south, single family north, et cetera, correct?
I do.
Okay.
I do.
For Westridge single family north, what type of permit approval did that project receive?
I think you're talking about at a land use stage, and Westridge Single Family North was a preliminary plat, and the process, I think you asked me about what process it goes through. Is that correct?
Sure. Yeah, I didn't, but you're welcome to tell us.
Oh, okay. Sorry. It went to the Urban Village Development Commission for a public hearing and recommendation to the City Council for a decision.
Great. And the Westridge Townhomes North project, did that also receive a preliminary plat, or was it some other type of land use decision?
It was a different kind of land use permit, multiple units like multifamily on a single parcel is the permit that needs is a site development permit, or SDP. And so that's the kind of permit they got.
Okay. That's all I have for questions for Ms. Sloman.
And Ms. Sloman, just to clarify that too, when you're talking about Westridge Single Family North receiving preliminary plat approval, that went to the UVDC for a hearing and a recommendation, then to council, that's for the preliminary plat stage, correct?
Correct.
Am I correct in remembering that I then issued a final plat decision on that?
You are correct.
Okay, just wanted to make sure I wasn't lost. Okay, thank you.
Not at all.
I'll turn you over to Ms. Koloshkova for cross-examination.
I'll make your life real easy. Hello, good morning. I have no cross.
No cross. Okay, so does that then conclude Ms. Sloman's testimony?
It does, and I am not going to call any other witnesses.
Oh, wow. Okay. Great. Thank you, Ms. Sloman. This was shorter than I expected. So then at this point, why don't we turn to our attorneys? First off, Ms. Koloshkova, based on that, did you have...
Sorry, it's missing. It's you.
She's typing very loudly.
Thank you. Okay. I'm sorry, Mr. Examiner, I did not hear you.
My question was based on what we just, the testimony we've just heard, did you have need to recall your witness or?
I do not.
To that extent?
This closes my testimony.
Okay, then in your mind, what's the best way forward at this point, Ms. Koloshkova? I, as you well know, have a preference for written closing briefs. I think you two have discussed this already in terms of we had this sort of late blooming issue, if you will, of the impact and effect of the Superior Court's decision that I know the parties wanted to brief, but any thoughts on timing?
Mr. Examiner, I mean, despite the fact that this is a very short measure of testimony, I hope that's not misleading to anyone that the issues are significant, you know, from a cost perspective to Polygon.
I'm well aware
So.
how complex the issues are and
Yes.
the money involved. I am painfully aware of these issues.
So I think it probably, going against my personal standard preference of oral argument, I do think that Ms. Hambley's request was appropriate, or the discussion was appropriate about closing briefs. I think I'm going to ask for a page limit as you did in advance. Otherwise, I'm concerned that Ms. Hambley and I could do a great job of writing extensively. And I, for one, don't know that I need to revisit things, but I get that the examiner probably benefits from written argument in this case. I am prepared to proceed with oral argument, though, if the examiner prefers that.
I certainly, I mean, I don't want to stop you from making a closing. I know that ultimately I would prefer to have, briefs to review and look at and think about, especially with the complexity of the issues. If you'd like to, perhaps we can do brief closing statements and then sort out the timing, or we can just skip to sorting out timing. I'm not trying to preclude anyone from feeling like they got to make the case they want to make. That's my major concern here.
Understood. Ms. Hambley, I'll defer to your preference. I think if we start getting into closing statements, it's going to be hard to not do quite a bit of back and forth, but I'm prepared if Ms. Hambley would prefer to go that route. Otherwise, I'm prepared to do closing arguments, and I think we can work out a schedule, or closing written, and we can work out a schedule.
My preference would be post-hearing briefing.
Okay, so that is my preference as well. I note for the record, I'm certain that both Ms. Koloshkova and Ms. Hambley had excellent closing oral argument that would have blown my mind, but we'll just see it in written form, and then that way I can track the municipal code references and the look up the cases and all that. So I guess my thinking would be just simultaneous submission of briefs. I think that probably makes the most sense, but does anyone have an issue with that?
I guess as the appellant, I do always get a little bit concerned. I would say I don't feel that I have a reputation of being overly pushy about replies. I would like to reserve the ability to reply if the city does raise a significant new issue that seems like it has to be addressed. I didn't anticipate that, but I would like to reserve that, not to be too difficult.
No, no. I know you not to be too difficult either. I think we're all professionals in the room. So what I would suggest is why don't we come up with how much time do the attorneys need for these briefs, and we can sort of include the option of reserving, the request to make a reply, and I can make a ruling on that based on what I read. Does that make sense?
Yes, I'm fine with that.
Okay. How long, in your mind, Ms. Koloshkova, would be reasonable for you to put something, and also what's a reasonable page limit in your mind?
I guess in terms of timing, I'd defer to Ms. Hambley. I know she's got a few things going on, and I want to honor that. Page limits, probably, what do you think, Kate? 10? Do you want to do less? Do you want to do more?
I was actually thinking 10 as well. Yeah.
We can get it done.
Okay.
And again, with the idea that this is building upon the prior briefing, so I have no intention of re-arguing what we've already written.
Exactly. So I guess it would focus on, based on the testimony that was heard today, kind of how you think that supports, your stance on what decision I make, and then in addition, any sort of briefing, because we didn't have much on it in terms of the Superior Courts and that particular issue would be what the focus of these are. Any thoughts on timing, Ms. Hambley?
Yeah, I apologize. I have some personal stuff going on in the next couple weeks. So if the parties and the examiner are amenable, may I suggest November 6th as the deadline for post-hearing briefing with replies to the following Friday?
Any issue there?
That's fine by me.
Okay, so the idea would be...
We've continued this hearing for 7 times. Let's get it right.
Okay, so I don't know where my calendar went. Oh, here, I've got a calendar. Got too many devices. I apologize. None of them want to open. Okay.
Well,
Calendar, so... quit. Okay, here we go. So Friday, November 6th would be the submission of post-hearing briefing, and
Kate, can you do
so Friday, November 6th, why don't we say noon, just that way folks have time. If it, goes to the clerk, it can still get sent out. But those can be submitted electronically. No need to also submit written copies. Does everyone agree with that? And please, you can submit them to each other. Please submit them to Candy so that the city maintains the official record, but you can also directly include them to David Ortman at my office so that all the folks involved are getting them at the same time. So Friday, November 6th would be submission of post-hearing briefing at noon, and then we'll reserve the idea, and this is what I would say, you're not gonna know what the other party says until you read it. So I think it would be reasonable to put a deadline of the 13th, 1 week later, or even earlier than that, to move to produce some kind of reply. Does that make sense?
Okay, yeah, so we would move to reply by the 13th, and then if the examiner grants it, maybe replies due by the 20th.
That would work for me.
Otherwise, I think 1 week for all of that together might be a little tough on the attorneys.
Yeah.
That works for me. I think, yeah, motions due the 13th with the actual reply brief, if granted, due the 20th.
Excellent. And then just to be clear on where we're at with exhibits, we were up to A22, I believe. And Ms. Hambley, maybe you can take written notes until we're through. The typing is a little loud. A21 is the one I don't think we've gotten yet, and I believe that was going to be the briefing, or am I mixing up my exhibits now? Hold on.
My understanding is that A21 was the stipulation, and Ms. Koloshkova already sent that around. The briefing I suggested, if we submit it to be an attachment to a declaration, which the examiner can then assign numbers to if he chooses.
Okay, there we go. Do you track with that, Ms. Koloshkova? You were shaking.
I'm sorry, I missed that.
Okay, so I was just trying to ensure we know what all the exhibits are. A1 through 20 were submitted in advance. Sorry?
Andrew, if you would prefer, I could send you the new exhibit A21, the new exhibit A22, and the exhibit C35 as submitted and emailed from Duana during our meeting, but not sent to you. But I can verify the copies to you as well.
Okay, yeah, I think that I might have been included, but just so I have them in one place, that'll be great. And then the only other thing was, and I guess it was going to be attached to the briefing. I'm trying to track. There was a request to have the briefing before the Superior Court included in my record somehow, and it was that going to be included as an attachment to the briefing? Is that what we had decided, Ms. Hambley?
That was my request, and just to clarify, I wanted to reserve the possibility of doing that, but I'm not guaranteeing that I don't want to submit more paper than the hearing examiner needs. I want to reserve the possibility of doing that. And what I had suggested is if we submit the briefing from Judge McHale's case to go along with our post-hearing brief, I would suggest that I write my post-hearing brief, I write a declaration, I attach the briefing from the McHale case to that declaration, send it to you. If you would like to assign exhibit numbers to that at that point, that's fine. Or we could treat them as exhibits and I can assign exhibit numbers and submit them as supplemental exhibits to go along with the brief.
Any thoughts on this, Ms. Koloshkova?
Matters not to me. Whatever's easiest.
But did you want them in the record? I guess that's my question.
Oh, I'm sorry. I don't think they need to be, but if Ms. Hambley wants them, I have no objection.
My goal would be to get them in the record, but I understood that, briefs and filings in that kind are part of the record for RUPA anyway. So whether they come in as an exhibit or as an attachment to a declaration doesn't.
Well,
I don't think it bears on that.
Okay, I see what you're saying. I guess just for purposes of, if I find the need to cite to them or something, I think it's easier if they have an exhibit.
I will assign exhibits to them.
Okay.
Happy to do that.
Great. So then I think we have a plan, November 6th, noon for the post-hearing brief. Then we'll cross that bridge of whether or not anyone wants to produce replies. I'm, generally amenable, depending on the parties. And I know in this instance, it's not going to just be well, I won't even comment further on other attorneys, but it's nice to work with professionals, which is generally the case in the city of Issaquah. So I think that's it. Did anyone have anything further that they wanted to mention before we finish up? Ms. Koloshkova?
Yes, it would be. Is it possible to get a copy of the recording? I am notoriously terrible at taking notes about testimony, so would help a lot.
You're not the only one, but yeah, Candy, I think when it's ready, we'll be able to send that around, a link to the recording for all parties.
Thank you. That will help a lot.
Yeah. Does that then conclude?
Sorry about that. Yes, mine couldn't get my mouse. Yes, I can get the recording out to you guys. I'm not sure exactly how long it's going to take, but it should probably be just in a day or two.
Oh, that's
report it to everybody on this call.
Totally fine. Thank you.
Okay, great. Well, then I think, wow, amazingly, before the lunch hour, we can wrap this up. So thank you, everyone, for taking the time, for being here. I know it's a challenging time we're in, and I wish everyone safety and good health. I myself have had some issues I've now overcome finally. So, things are moving forward. And with that, we'll go ahead and end the hearing. I did want to note, unrelated to this matter, just for city staff there in Issaquah, is the hope is by Friday you'll have that other outstanding decision that is long outstanding, and my apologies on how late it is. I fully am aware of that. But that is the plan moving forward. So I think with that, we can end the hearing. Thanks so much, everyone.